All right, let's go ahead and get started. Hi, everyone. Welcome to HYLA's December Tuesday CLE event. Today, we will be hearing from two great speakers, Tyler Flood and Zarwaki Dugar-Brown, about the DWI process. But before I formally introduce our speakers and we kick things off, I have a couple of housekeeping items. Please note that this is a webinar, which means we can't take you off mute if you raise your hand. So if you have a question, please use the chat function to send those. And feel free to send me a message on Zoom if you have any technical or HYLA related questions. I'd be happy to help. Our speakers are going to each give about a 30-minute presentation on their respective topics, and they will take questions at the end of both presentations. So please ask questions as they come. You can just put them in the chat and that will be fine. Please remember to self-report your CLE credit on the State Bar of Texas website. I'll be putting the course number in the chat about halfway through the program. But remember, it's your responsibility to report the amount of CLE that corresponds with the amount of the program that you actually watched. We will also be putting this program up on our YouTube channel, but there is no CLE credit for watching the recording, only for watching it live. Thank you, everyone, for listening to my little spiel. Now it is time to get on with why we're all here. We are delighted to be joined by Tyler Flood and Zarwaki Dugar-Brown, who will be discussing the criminal and administrative sides of the DWI process. And with that, I will let Tyler take it away. Again, if you have any questions, just shoot me a chat.
Thanks, Katie. I'm Tyler Flood. I'm a criminal defense attorney, and I focus primarily and only on DWI defense and other intoxicated related cases. So I have a PowerPoint. It's 69 slides. I'm going to go through it pretty briskly, but since this is being recorded, there are some slides that have a lot of law on them, which is good for reference. And I'll try to pause on each slide. So in the replay, you can go back and get that information, but I'm not going to have time to read through every single slide. But I do have a PowerPoint. There's some entertaining slides I think you'll really enjoy. So I'm going to go ahead and get started. So I don't go over my time. I'm going to go ahead and try to share my screen here. And just so you know, I'm going to be speaking from the defense perspective, and Zarwaki's going to talk about the administrative civil aspect of license suspensions. We don't have a prosecutor viewpoint in here, so just, for a prosecutor from court, so just keep that in mind. Are y'all seeing my screen now?
Not yet.
Your screen. Well, now it's. Oh, it's not. Ah, I see what the problem is. Now, are we good?
Yes.
Okay.
Yes.
What just happened? Oh, okay. So you can see the cartoon character?
Yes.
I just thought this is a perfect example to epitomize, what we do as trial lawyers. This is a perfect opening statement. This is Bruce playing an attorney from Family Guy cartoon. And it really sets the tone for this speech today.
Hey, everybody. Today's the big day. That's all, Your Honor. Good, good.
Perfect
Hey,
opening
everybody.
statement, concise, to the point. Just kidding. I just like to use that because it cracks me up. If anybody needs to ask questions, my email address is tyler@tylerflood.com, and my phone number is 713-224-5529. So if you see anything that you have questions about, feel free to reach out to me. Everybody asks, what do you do these days? Now they draw blood. They didn't used to draw blood, so it was easy. You just said, don't blow, and there was no BAC. Now it's a little more complicated. And the best, most every single attorney I know will still say don't blow. And there's good reason for that right now, is because now a lot of times in Harris County and surrounding counties, even more, officers are threatening they say, well, you might as well just blow, because if you don't, we're just going to get a warrant to get your blood anyway. But they won't. And if you don't blow, they were kind of bluffing and they don't go get a warrant. And then you have no BAC and they don't get your blood in every situation. So you should never just this is a defense opinion and defense perspective, but even prosecutors and judges and police officers, when they are in the situation, they follow these rules too. Just don't blow, don't give consent to give your blood. Make them get a warrant. And then once they get a warrant, they are going to get your blood, whether they hold you down, strap you in. At that point, you have to consent. You have to cooperate with them if they get a warrant for your blood. So that now it's more of a know the information, know what the consequences are, and then you make an informed decision. But these are my best tips. Blood warrant cases can be defended successfully. We defend them successfully regularly. And the reason is because there are many more people involved. There's more room for error in the warrant process and the blood handling and testing process. But that's kind of it in a nutshell. I had to put a shameless plug in there, then call me. Here's a little bit about my background. And again, I'm going to go through some of these slides very quickly. DWI is sometimes referred to as an opinion case because most of the time it's one officer out there or two, and it's very subjective. They administer a field sobriety test and they come in and they give their opinion of what they saw. So sometimes when you explain that to a jury, they understand that this isn't, all these tests aren't completely objective. Many of these of the facts and the testimony from these officers is really their personal opinion, and that's important to remember. This is some learning objectives. If we had an hour, we would go through more of this, but I'm going to be respectful to Zarwaki because she's got very interesting and important information to talk about as it relates to DWI. Here's a slide that just gives you the ranges of punishment of DWI and felony DWI. Felony DWI with child passenger. If you're 14 years old or younger, even if it's your first offense, it can be a felony with the DWI with the child passenger. And then there's intox assault and intoxication manslaughter. Intoxication assault and intoxication manslaughter, those are interesting cases because while the consequences and the facts are much more serious, you have seriously injured people or fatalities involved, there are different elements for the state to prove, and it becomes a very interesting legal analysis of causation. It's not just intoxication, but they have to also prove that because of the intoxication, it caused the fatality or the serious bodily injury. It's not an open and shut case, and there's some very interesting legal issues in dealing with those cases. So people ask a lot, and most people call me and they say, hey, I got a DUI. Well, number one, that tells me they probably weren't born and raised in Texas because it is DWI. DUI is what it is probably referred to in the majority of the states around the union, but there is actually, so if you're DWI, that can be from alcohol or drugs, even prescription medication. You can have too much prescription painkillers and no alcohol at all and still be driving while intoxicated. But I do want to clear the air. There is such thing as a DUI, but it is not what everybody refers to it as. They get DUI and DWI confused. So a DUI is it's a Class C offense, which is the lowest level, which is the equivalent to a traffic ticket, and then B is higher, then misdemeanor A is higher, then you get into felony. But this is, I see this a lot when there's like kids driving around in the villages, right? And the village's police department pulls them over. They think they've been drinking. They can smell a little bit of alcohol, but they don't think they're intoxicated, or they don't want to arrest them for DWI. So the threshold here, what they have to prove is just any detectable amount of alcohol. If an officer just says, I smelled the alcohol, that can be sufficient for a conviction. But this is not DWI. They don't have to prove you're intoxicated. It's a Class C offense, but they will arrest a person, a minor, and take them to jail because they don't like them drinking and driving. But it's only a Class C, but there are license consequences that can go along with that. It can cause the license suspension for the minor. So now you know the difference between DUI and what we deal with in court, which is DWI. Okay, here's so DWI is under Penal Code 4904. Here's the elements. It talks about a person requiring to serve 72 hours of confinement. That the way that is handled practically in the courts is, let's say you got a first offense DWI. If you go in and you just didn't hire an attorney and pled guilty, and they offered you what's called a time served deal, meaning you just pay a fine, you don't have to go to jail, and there's no probation. The way that they get around the 72 hours requirement, at least in Harris County and the surrounding counties, is they give you credit for the time that you were already in jail. And since you get 2-for-1 or 3-for-1 credit in the county jail, it washes the 72 hours. So you don't have to actually serve 72 hours. You go to some smaller counties around Texas, and they, I think rightfully so, they think the 72 hours means 72 hours. So everybody kind of looks at that a little bit differently. Operating is a big issue in DWI. There is no definition of operating that you will get in a jury charge. And this is one of the most highly contested and constantly changing areas of DWI law. It would be great if there was a clear-cut definition in the jury charge, but there's just not. What I'll tell you now, it's been a very steep slope in appellate cases defining or finding that there was operating in situations where you never thought that this would actually be operating a vehicle. Operating does not have to be them seeing you driving. If they can prove that you were operating at some time and were intoxicated, you can be convicted for DWI. They don't have to see the car moving. Now it's like they don't even have to have the engine or see the engine on. There are too many cases to go through about that right now, but some of the questions that come up are, can you be arrested for DWI if your keys are in the ignition but the car's in park? The answer is yes. And the way they prove this is through circumstantial evidence. So it might not be operating, but if let's say they feel the engine was warm, which indicates that you drove recently, or there are people that will go out and charge their phone that weren't driving at all. So it becomes really difficult to determine if a person was operating. One of the other circumstantial pieces of evidence officers will look for is who the vehicle is registered to. Keep in mind that if they ask you, were you driving, just so you know, an out-of-court statement, an extrajudicial statement that you were driving is not sufficient alone to prove you were operating. They need more than that, more circumstantial evidence. Can you be in your car charging your phone and still be arrested for DWI? Yes, you could. You can definitely be arrested. That doesn't mean that they can convict you for that. They would need more evidence to prove that you were operating. But there are cases that have been appealed, and these situations have been upheld on appeal. Can you be convicted of DWI if you're found standing outside your car with your keys in your hand and the car is not running? Possibly, yes, because all they need, if they have a witness that says they saw you pull into this parking spot, or they were following you, the officer does not have to see you driving or operating. They just need to be able to put at a point in time that you were operating a motor vehicle. Here's some examples that you can reference on the recording. What is a motor vehicle? Well, I get this question a lot. Can I be arrested for DWI on a horse? No, because a horse is not a motor vehicle. However, there have been instances where people have ridden a horse intoxicated on a road and caused other people to crash, and major consequences, major injuries, fatalities. So there are other crimes that person could be charged with. For instance, involuntary manslaughter, if their actions were so reckless that it caused a fatality, but you can't be charged with DWI. I also get this a lot. I like to play golf, even though I'm not very good at it, but everybody always asks, can I get a DWI driving a golf cart? Well, if you're on the golf course and you're not causing any problems, you're not going to be arrested for DWI. A golf cart is a motor vehicle. So, you know, a lot of times in these subdivisions, there's golf courses, and there have been people arrested for DWI driving a golf cart. And the situation is, it's almost the same set of facts every time. And it's kind of sad and comical, but they're driving away from the golf course back to their house on the road in the subdivision, and they're hammered and they turn and they throw their wife out of the driver's seat and beer goes rolling all over the road. The cops come, they can arrest you for DWI in a golf cart. It's on a road, it's a motor vehicle. This is not a motor vehicle as far as DWI purposes. So a train is not. So technically, the conductor of the train could be chugging his Sky vodka bottle, and that would not be considered a DWI in Texas. Public place. This is a hotly contested issue as well. Almost everything now is a public place because of the appellate decisions that have come down. We think, can y'all still hear me? I can hear somebody talking in the background or.
Between us.
Hey guys. Okay. Okay. I didn't know if I was, can y'all still hear me? Okay.
Yes.
I'm assuming yes. Okay, great. People used to think that, well, I'm in my gated apartment or condo facility. That can't be a public place because we have to enter a code and there's a security gate that doesn't let anybody in. Well, the appellate courts have said that is a public place. And what they look to these days is the amount of access that the general public has to that location. And they say, well, somebody can follow you into that gated community. So that's a public place. They've even found military bases to be a public place. This is probably one of the only places that might not be a public place in Texas. If you're on your ranch behind your gate on your dirt road, this is about the only case that has determined this is not a public place. So you can drive drunk on your ranch. I don't recommend it. Let me preface all this with my best advice is always don't drink and drive. It is the same streets I drive on that we all drive on. And that's the best advice I can always give. But we're going over what happens when you're in this situation. So there aren't many places that are not a public place anymore. Even if you're parked in your driveway at your house, they can still convict you because someone might have seen you drive up there, but they also have another exception saying it's a suspicious place. If you're in a suspicious place, and they've determined kind of unbelievably that your driveway can be a suspicious place. And they say that based on the facts, like it's suspicious because why were you racing to get there if you knew you were intoxicated? It's very fact specific, but just so you know, not many sacred places that are not a public place. Here's some examples. I'll leave that up there for y'all to look at, but a boat marina, a closed park, a gated community. Watercraft. This is interesting because you can have boating while intoxicated, and I've handled many of those. I've had several clients from Lake Conroe that have been arrested just on their boat, just idling, having a good time with their friends and family in their cove. And the problem is that to make an auto traffic stop, an officer needs reasonable suspicion or probable cause that you were committing some, traffic violation or criminal activity. It's not the same on the water. The game wardens can come up and do a water safety check for anything, any reason. They don't need any probable cause to think that you were drinking. And so they use that as a reason. They'll come out, they'll stand back with binoculars and watch the captain of the boat drinking beer. And then they will approach and they'll do the water safety inspection. And then it turns into a DWI investigation. The funny thing is, and Zarwaki knows about this, but you can have boating while intoxicated. You can have a boating while intoxicated conviction, and they will suspend your driver. They will try to suspend your driver's license. And you can have a suspended driver's license for your car without ever having a DWI if you were boating while intoxicated. So just roll that around in your head. This is kind of just a little video. I don't think I have time to show it, but this is where they go up and actually. oops. Let me go back into that one. They just go up and the guy says, we've got everything. And the game wardens are kind of sassy. They say, well, how did you know what we were going to ask for? And of course they do make them show everything. And then they ask them to get on their boat and take them in for sobriety tests. Open container. Here's the law on open container. You'll notice that. So if there's an open container anywhere in the car, it's an open container. If it's in the bed of your truck, it is not. If it's in a glove compartment that is locked, it's not, but nobody really locks their glove compartment. But I think you'd find C interesting. If you're in like a Suburban and it's behind the very last upright seat, if it doesn't have a trunk, it's not considered to be in the passenger compartment. So go figure that. If they convict you of DWI and they make an affirmative finding that there was an open container, the law says that you're required to serve 6 days in county jail. That can also be probated, however. So in my 23 years of doing this, I've never had anybody there's been an affirmative finding of an open container, even though there's been open containers in the vehicle. So it's hard for them to prove. So the way they determine if a person is intoxicated are using the National Highway Traffic Safety Administration 3 standardized and validated field sobriety tests: the horizontal gaze nystagmus, the walk and turn, and the one leg stand. This is the eye test, the walking the line, and the balancing on one leg. The state doesn't have to prove what the defendant's normal faculties are. There's no way they could ever know that. And so when defense starts saying, well, you don't know what his normal faculties are, that's objectionable. It's what a normal person, it's kind of a reasonable normal person standard. HGNs, where they pass the pen in front of your eyes, they look for different types of involuntary jerking. You can't control it. You can't stop it. If you show 4 clues or more, the studies indicate that you're not really supposed to equate it to a BAC, but they do. If they do, they say that it shows that you would be a 0.08 or higher, or that it's highly reliable to show that you might be intoxicated. And this is one you can't control. This is a picture of how it kind of looks. And this is one with no nystagmus. And this is the one with the actual jerking. You see it jerking over there when it goes to the corners a little bit. So that's what they're looking for. Okay, walk and turn, there's 8 clues. If you do 2 of these things wrong, they say you're intoxicated. If you miss touching by heel to toe by half an inch, they say you're intoxicated. If you do an improper turn using this really weird turn method, they'll say, well, that's 2 clues and that indicates you're intoxicated. I won't show this, but this is one where the guy walks forward and then he walks backwards. He doesn't turn around and he walks backwards, arguably better than he did walking forward. And I think that would be even more difficult and show the presence of your physical faculties. So the one leg stand is the last of the 3. There's 4 possible clues. If you put your foot down, move your arms more than 6 inches away from your body, or you hop or you sway. If you do 2 of those things wrong, they will say that is a sign that you're intoxicated. But field sobriety tests can be hard to do. I want you to watch this officer this deputy trooper trying to demonstrate the field sobriety test.
Lift your feet together, hands to your side, ask to hold like either your left or your right foot about 6 inches off the floor. That's me.
He's having a lot of trouble just demonstrating. He fixes his belt and then he leans up against the wall and he does it again just so he doesn't fall. The one leg stand, and these are cases where even though the person doesn't look good, we were able to find other legal reasons to fight these, and not bragging at all, but we actually were able to win this case because of officer credibility issues. But watch this stellar performance. This is one of my highlight reel one leg stands. So he said, man, this is really hard if you haven't been exercising. But the officer wasn't very truthful on the stand and the jury didn't like that and they found him not guilty. Let's talk about BAC and extrapolation real quick. My time is running short. they've got to prove that you were 0.08 or higher at the time of driving if they're going to convict you using that method. The 3 ways they can prove intoxication are 0.08 or higher at the time of driving, not having your normal mental faculties, not having your normal physical faculties by reason of introduction of alcohol or drugs. So, and just because you might these are the ways they obtain a BAC using the Intoxilyzer 9000, drawing your blood and analyzing using headspace gas chromatography, or a urine specimen, which we see that's much more rare and more attackable, less reliable. But they've got to prove what your BAC was at the time you were driving. So if they test you an hour and a half after you were driving, that's just a number on a piece of paper. Then they've got to go do a calculation called retrograde extrapolation, which is just a fancy word for calculating back in time what your BAC might have been at a point earlier in time. And they have to have a lot of variables to do that. Most of the time, the officers don't get all those variables, and they can't say what the BAC was at the time of driving. There are rules about this. The breath, if you have a breath test, the operator must remain in the subject's presence for at least 15 minutes before the test. It's called the abstinence period or the observation period. Here we have one where if I showed you this video, the person down at the bottom, the lady standing there in the blue shirt at the bottom of the screen, she's the breath test operator. She walks out of the room and closes the door 3 minutes before the breath test, and that renders this breath test illegal according to Texas law. The officers are not breath test operators, so they don't qualify for that 15-minute observation period. It has to be a breath test operator. They can combine times, but they all have to be certified breath test operators. Blood draw law, who can draw and what location and atmosphere is governed by Texas Transportation Code 724.017. And we make a lot of hay with this in trial because the state sometimes can't prove they were qualified under, the blood drawer wasn't qualified under one of these 5 categories, and they can't prove that it was taken in a sanitary place. You have to have a warrant. This is old law from 2013, but it changed everything, the lay of the land and DWI. You can't draw blood if a person refuses without getting a warrant. If you do, that's illegal. This is Marianne Lindbergh. She was the Travis County DA. This is the chair that they used to draw your blood. She went to go watch a movie and had a couple glasses of wine, and she was arrested for DWI in Austin, and she got real angry. They had to put the spit mask on her. This is the environment they draw blood in. It doesn't look, this was in the beginning. There's mold around the air vents. There's trash laying right next to where your arm would be. Arguably, maybe not sanitary. Here's a picture of, you shouldn't use any type of alcohol when administering a blood draw, even though isopropyl alcohol is what is in hand sanitizer, and gas chromatography can distinguish between isopropyl and ethanol. Ethanol is what we drink, but you'll still have juries will be bothered, and it's still not a good idea to have isopropyl alcohol in the room. It's 70% alcohol and hand sanitizer, and she's slathering up tons of hand sanitizer before the draw. These are vacutainers. Blood should, for alcohol testing purposes, should only be drawn in a gray top tube because it contains chemicals in the bottom, potassium oxalate and sodium fluoride. And those vials have to be rotated at least 8 to 10 times for them to mix those powders. So that's something we look for. This is a picture of a headspace gas chromatography, but this has a mass spec on the end, but I actually have one of these minus the mass spec on the left. I have this fully functional blood laboratory with that exact model GC in my office. We're not accredited. We like to do experiments, and it's fun to play around with. This is kind of what they don't test your blood. They test the air above your blood. That's why it's called headspace. This is what a headspace vial looks like. So they transfer a tiny drop of your blood into these headspace vials, put internal standard in it, and then they program it in all those trays and called sequencing, and then they turn it on. That's me at ours. That's the oven. That's what we call the oven. It heats it up. There's pipettes. Very important that pipettes are all calibrated properly. This is what the machine comes out of the machine. And the way it looks complicated, but it's real simple. All they do is they measure the area of these peaks, like how big is the peak. And so you see this the one that says 1.545. That's the time that it comes out of the machine. They say they know everything that they put into the machine that comes out at 1.54 minutes is ethanol. And so then they just measured the size of the peak. The smaller the peak converts into a lower BAC, the bigger the peak converts into a higher BAC. I'm going to just leave this up there for the recording. So we talked about retrograde extrapolation, and I'm bringing this to an end. I just have a couple more slides. This is what a standard drink is, 1.5 ounces. I think when I started out, it was 1 ounce and 1.25 ounces. Most people don't drink standard drinks, especially if you're at your house and you're self-pouring. BACs are going to be different between men and women on the same number of drinks. And the reason is that men have more water in their body than women. I know that sounds strange. Alcohol is attracted to water. So in men, there's more water for the alcohol to dilute, and it causes a lower BAC, whereas women have less water in their body, less places for the alcohol to go and dilute. And so it's going to be a higher BAC. This is a retrograde extrapolation curve. The key thing here is that you could be below a 0.08 at the time of driving where the 0.07 is, and your BAC can still be rising for up to 2 hours after the time of your last drink. So when they test you, you could be higher, and then you can be lower back at the time of driving. And that's what they have to prove. If they can't, then you can get them to say, I don't know what the BAC was at the time of driving. So I'm going to leave this up for the recording so you can refer to it. And then this is where we segue into Zarwaki's presentation. This can have license consequences. If you have a first offense DWI, DPS will attempt to suspend your license for if it's first offense and you've had no other related alcohol contacts. It's 90-day suspension, what they're seeking, if you consent to breath or blood. If you refuse, then they are seeking a 6-month suspension. So that's a separate hearing, separate from what we're doing in court. DPS has their own prosecutors. That's who Ms. Dugar-Brown is. She works for DPS as a prosecutor. And I've been dealing with her my whole career. We have a very professional working relationship, but just keep in mind, there is no such thing as an automatic license suspension. When a person gets out of jail, their license is not suspended. And there are processes to contest a license suspension. This is just showing some of the cases that we have defended and the reasons why. This is the summary, what to do, and that's it for me. So there's my information. If you have any questions or comments, I'll be happy to answer them. Thank you guys very much. I'll stop sharing now.
Good afternoon, everyone. I'm Zarwaki Dugar-Brown. I'm a staff attorney with the Texas Department of Public Safety in the Administrative License Revocation Program or Division. We, as Tyler was stating, the ALR is separate and distinct from the criminal DWI case. ALR is specifically and strictly a civil matter related, shares some quasi-criminal in that it arises out of the criminal case. What I'm going to share with you is just some practice tips, some helpful resources to utilize as you practice DWI or practice ALR hearings as well. And so I'll go and give you a brief synopsis as to what the ALR hearing is, how to make a request, give you some practice tips, and then you have the other resources on the screen. And so you make a ALR hearing is the administrative license revocation for a suspension of your license pursuant to a DWI offense. And so we are strictly looking to suspend the license for that contact. We also suspend licenses, as Tyler alluded to, for BWI, which is boating while intoxicated. And the DWI, if the person has a commercial license, will also affect the commercial license of that driver, regardless of whether or not they were actually driving the commercial vehicle at the time of the offense. And so with that being said, where do you make your request? You make your request to Austin. It's now called Enforcement Compliance Services. And so that is, you have 4 different ways you can make your request, and it's all on the screen for you. You can either call in your request, you can email your request, you can fax a request, or you can mail in the request. But you have 15 days to make that request after the subject has been arrested. And so that's an important timeline to remember, because once the 15 days have expired, you will not be allowed to make a request that will be a valid request. And so the license suspension will then take effect after that 15 days if no request has been made. And so again, the purpose is solely for license suspension. And I want to make certain that we all are aware that the dismissal of the criminal case has no effect on the ALR proceedings. The only way the criminal case can affect the ALR proceeding, which would make us dismiss the case, is if there was an acquittal in the DWI criminal case. If there's an acquittal, we dismiss ours. A straight dismissal or plea down does not affect the ALR proceedings. Also, ALR proceedings, we do not grant occupational licenses. The SOA judges, the State Office of Administrative Hearings, that's the agency assigned to hear these matters and adjudicate them. They do not have the power to grant occupational licenses at ALR hearings. And so once you make that 15-day request, then the department will send a notice to the client if that person is pro se, or to the subject, rather, that person is pro se, or to you as the defense attorney. And so in that notice, it will give you the date, time, and now everything is Zoom for us, Zoom hearing for the ALR proceedings. It is very important that you, in your request, provide accurate information. Please put your physical address, as well as include your email address that is listed there as well. And it's important because since we're now electronic, we e-file everything. And then you have to e-file everything to the department. When you go into the e-file service tab, please put in your service contact information. For some reason, e-file allows you to e-file or e-serve without actually putting your service contact. But when it's time for the court to issue information to you, if you do not have your service contact, you may get a nice little letter from the court indicating that you should include your service contact information. A caveat about e-file: for some reason, e-file does not like AOL email addresses. So if you have an AOL address, please change it. Sometimes it goes through. Oftentimes, it does not successfully transmit via e-file to AOL addresses. Also, in practicing for the ALR hearing, there is an automatic reset that is granted. It's called a 5-day reset, which means if you make a request for a reset or continuance 5 days before the original date of the hearing, then it's automatic. You will be granted. You do not need to contact DPS and ask for a position on that. You simply just file it, e-file it with the court, serve it upon DPS as well, and that reset request will be granted. In e-filing, we also want to make mention, it's defaulted for service and e-filing. So if you leave it on the default, the court will get it and DPS will get it, because everything you file with the court must be served upon the department. So please do not change it. If you change it to just e-file, then when we get to the hearings, DPS will ask to see what you e-filed and ask you to show proof of your notice to the department. Your failure to notify the department can get things quashed, specifically your subpoena. And so with that, the website that I have provided, the SOA website, if you go on the SOA website, it has all the rules for the proceedings. It has helpful forms where you can get your motions. There are motions for continuances there. You can get your subpoena forms there. You do not have to draft your own subpoena forms. It's all listed right there. Please don't change them. It's easy to read in that manner, and then it'll make the process run a little smoother, because when you start changing things, sometimes you leave out things. And then again, when the hearing comes, something is not complete, the subpoena gets quashed. The purpose of the ALR hearing is to run, ALRs are supposed to go smoothly, quickly. They're not long and drawn out proceedings. And so any of those changes that may be made can delay the process. Might get a continuance, might not, depending upon the judge. So just helpful tips just to follow what is provided. It's all there for your access. The subpoena requirements, again, are listed on the website, but so that you are aware, when you issue a subpoena, you must serve it on the officer a minimum of 5 business days before the date of the hearing. And then once you serve it upon the officer, you also have to serve that return upon DPS. But let me back up. When you issue the subpoena, you also have to serve the issued subpoena to DPS. So we should get it twice. When you issue the subpoena, we need to get it. And when you serve the subpoena and file it with the court, the return of service, you also should serve upon DPS that return of service. When requesting those hearings, again, if you include the DIC 25, your client, when they get arrested, every subject gets a DIC 25 for those who have failed a specimen or a test rather, and for those who have refused, they will get a DIC 25. That DIC 25, if you mail that in with your request, you will have everything that is required. If you don't mail the DIC 25 in, again, on the screen is the list of everything that you need to have included in that request in order for it to be a valid request. I say valid request because if you miss items, then the department will send you a note indicating that you have failed to make a proper request. They will tell you what is missing and then give you a certain amount of time to comply with that. I have seen matters where the letter went out, the defense attorney did not respond in the time that they were given, no hearing was held, and the license suspension went into effect. They argued that they requested, but because they were missing items, it was not a valid request, and therefore their license, the client's license got suspended. So we say include the 25 so you don't have any issues. But if you choose not to include the 25, please read everything that is on the 25 at the bottom. It tells you exactly what you need to include in your request in order for it to be valid. And then before I close out, I just want to make you all aware again of those resources. So there's a SOA website that has your hearing forms. You can also check the status of your case at the SOA website. So if you ask for a continuance, but you didn't get the order, you didn't receive the order, you can plug in the cause number in the SOA website, and you can pull up the case and see whether or not it has actually been continued and what the hearing room number and date is if it has been continued. Also, the rules for procedure for ALR, we're governed by a total separate set of rules. It's Texas Administrative Code, Section 159. But again, that is on the SOA website as well. It tells you about discovery. It tells you about how to subpoena, all those rules governing that, the evidence to be admitted, all your e-filing requirements, everything is there for you to follow along. Also, another helpful number is the SOA docketing number. That is if you have a case set, or let's say you've made a request, but you have not received the notice of a hearing, then you can call SOA docketing to find out what the notice status is. Also for DPS, the Enforcement Compliance Services, you can, for ALR inquiries, we have a phone number listed for you there, as well as for non-ALR inquiries, there's a different phone number. Non-ALR is for habitual violations, for any other suspension that the department could suspend a license for, you would call that separate number. Also, as a practice tip, you can always reach out to the local ALR office for any assistance, just in case something went awry or you want to verify that you did receive something. Please feel free to reach out to the local office we're more than happy to assist in that manner, because again, we want to make sure that the process runs smoothly. And then after the ALR is all said and done, and the department wins, let's say the department wins its hearing, most times, sometimes people can and will appeal those decisions. If you decide to appeal the ALR decision, please send a copy of the petition to Austin. It's found in the Texas Transportation Code, Chapter 524, as to where to send the appeals, but also send it to the local office that handled the underlying ALR. And we say that so that all bases are covered. Again, everything runs smoothly. You have proof that you've sent it to us and we can actually receive it. And then again, it just makes the process run smoothly. I will stop now so that we can have time for questions and answering. Thank you.
Thank you, both of you. Yeah, we have a couple of questions. So I think everybody would like to hear about what each of your, craziest or, most off the wall story is that y'all have experienced, to the extent that y'all are willing to share.
I'll share this. We routinely, when we get to the hearings, because we don't get to talk to the officers before the hearing. Most time we have first contact at the hearing. We always ask the officers, did anything out of the ordinary happen? Did something happen that we need to be aware of? Officer says no. Defense starts questioning. He says, tell me about the explosion. Like, what explosion? So, of course, we're looking like, what happened? How can I save it? We don't know what's going on. It just has to happen at that particular point in time. So that's my crazy story.
I wanted to reiterate something that Zarwaki said, that, in most every single thing that we do in the law, criminal and civil side, there is some remedy for missing a deadline, right? I can't emphasize enough about what she said about the 15-day deadline to request a hearing to contest a license suspension. If you miss that, there is no remedy to fix that. When she said that, she was speaking the truth. You can't. There's no oops, I messed up. Give me a second chance. That's one thing. You got to get in within 15 days. So as a practice tip, if you're a defense attorney and somebody calls you, said they had a DWI, but if they don't hire you immediately, make sure you ask them what the date of the arrest was. Because if you're right at the 14th day, I think because they contacted you, I think it creates a duty for you to advise them. If they don't hire you and they call back after that, you miss the 15 days. And this is an integral part of DWI defense. So as a courtesy and just being a good lawyer, always try to figure out what their arrest date was. Even if they don't hire you and advise them, you have to request a hearing. They can do it on their own. There's instructions on there. It's on the website, but always ask that question. I see a lot of lawyers messing up, but I do have a interesting story. There are so many, and my kids I come home sometimes, and when they were younger, they say, Daddy, tell us a fun court story today. So it's hard to come up with them all on the spot, but there's one that's very interesting. And just to kind of illustrate that, there's 254 counties in the state. Everybody's got different philosophies around the state about drinking and driving. Some are very strict, like Montgomery County. Of all the places I've practiced around Texas, I think that they are more strict, more on the ball, more aggressively pursuing and getting the message out about DWI. Harris County is a little different story, but I tried a case in Giddings, Lee County. It's like as you're driving through, coming home from Austin, and there was a guy that my client was drinking a Mickey's Big Mouth 40, a big bottle, a green bottle of beer, as he was driving through Giddings. And well, he got tired and he stopped at a warehouse and had a nap during the middle of the day. The workers called the cops. The cops came out. They never showed my client on video at all, but their dash cam was on, and they put the Mickey's Big Mouth on the dash of the cop car. And that's all you ever saw on the dash camera. That's the only thing that was ever on video, was this big beer. And so he had hired another attorney, but he wanted to go to trial. He hired me. I came in and took over the case, and So I went in and the elected official, Martin, his name is Martin Plocky. He's a real good guy. He told me, not in an intimidating way, but came up and said, Mr. Flood, I've never lost a jury trial ever. I was a little intimidated by that. And I didn't really know the lay of the land that well, but when we went on the day of trial, only 16 jurors showed up for jury duty, 6 of which had their own DWI convictions. So I'm thinking, this is an interesting county. It seems like there might be some drinkers and drivers around here. And they said, well, if we can't get 6 jurors out of this panel, I'll send the bailiff to Walmart and he'll go grab some more jurors from Walmart and bring them back to supplement the panel. I thought he was joking, but this stuff really happens in some small counties. But we got 6 out of that panel. So during trial, we during a break, we noticed that, or after the break, we noticed that Martin Plocky brought in a black backpack and we didn't know what was in there. So during trial, it was supposed to be the big moment. And he asked the officer, what size beer was this person drinking? And he pulls out a Miller Lite 12-ounce can and puts it on a council table. And he says, was it this big? And the officer says, no. And so then he actually got a Mickey's Big Mouth 40 and he pulls out the big green bottle and he puts it on a council table. And he said, was it this big? And the officer says, yes. And it was like, oh my gosh, what, like the moment in trial. And we took a quick break. The judge said, send the jury out. And I thought I was in trouble. We did something wrong. That's usually what it means when the judge says, send the jury out. And he said, counsel, y'all approach the bench. And I was like, what did I do wrong? And this is what the judge said. We leaned over and the words he used are important. He said, I can finish one of those in 5 miles. That's what the judge said. That was it. That's all he wanted to tell us. He didn't say I could finish it in 5 minutes. He said 5 miles. So I'm thinking, okay, we got 6 people on jury. The judge is admitting that he drinks one of those and he knows how many miles it takes him to finish that beer. Needless to say, we got a not guilty from the jury. I don't think they would have convicted anybody in that town for drinking and driving. And afterwards, Martin Plocky, the DA, he said, good job. He said, by the way, that was the first jury trial I've ever tried. That's why he had never lost one before. But anyway, that's one of my funny stories.
That's awesome. Thank you both for sharing that. I imagine there's a bit of a timeline difference between the criminal and the civil ALR side. What is that, what's the difference of those?
Yeah, the ALR hearing is typically within a few months of the arrest. And if you set your case for trial in the court, that's about a 9-month to a year process. So, we don't have depositions in criminal law. So the ALR is civil in nature, and that's as close as we have to a deposition as we get. So it's kind of a catch-22. So it will happen early on in the process while you're defending the DWI in court. So on the one hand, most people want their license to be saved. We have to subpoena the officers to be there, but then we cross our fingers that they don't show up. This is no secret to Zarwaki. If they don't show up, then then the ALR proceeding is dismissed and the license is saved. But I don't get a chance to question the officers under oath. If the officers do show up, the license is most likely going to be suspended. We've won a few cases on the merits, but that's very rare. So we will get to question them all about, well, as much as we can under oath. And we use that as an opportunity and a tool to try to start, picking apart parts of the case, the reason for the stop, the probable cause, and it's on the record. So we can take it, if we get good testimony, we can take it over to the DA sometimes. And sometimes, I mean, these officers show up after they just got off night shift. They're not prepared like they would be for trial. And sometimes we can gut their case, get them to say really damaging things that we can use to help get the DWI dismissed. So we try to save the license, but then also use it as a discovery tool if they show up.
I will say along the lines of using it as a discovery tool, do not send interrogatories. The department does not answer interrogatories. We have some that try to do it, but we don't answer interrogatories.
It's very entertaining. The ALR world is extremely entertaining. Zarwaki and I have seen a lot of interesting things, lawyers that are out of their pond, out of water. And it's hard to keep a straight face sometimes, but it's a real good education. And you're able to join and watch at any time. They're all on Zoom after COVID now. You get to see a lot of what not to do,
It's all
as
public
well as
hearings.
probably more of what not to do. I would say.
So it sounds like it's a pretty high bar to not get your license suspended if you've gotten to that point. How does somebody, like, what are the defenses to not get that result?
To not get your license suspended with an ALR?
Yes.
If they subpoena the witness, how our case goes away, mostly, majority of the time, is if the witness does not show up. If the arresting officer or any officer involved, you get to subpoena two witnesses, the stopping officer and or the arresting officer. If either of those two do not show up, we can't introduce what that officer said. If that is detrimental or paramount to our case goes away. And you keep the person keeps their license.
The interesting thing about that is procedurally, we don't want the officers to show up, but the rules are that we have to subpoena them and serve them. And there are strict deadlines on serving those returns and serving the subpoenas. So it's counterintuitive. We have to subpoena them, commanding them to show up, but then we hope that they don't. We hope that they ignore the subpoena. And it varies from county to county, but the majority of the officers, in my experience in Houston, they've been around enough or have been told, you don't need to show up or don't show up, but they don't show up the majority of the time. But if we did not, and you see this happen a lot, some lawyers won't subpoena officers. They don't really know how to handle it, and they'll make arguments, and they didn't follow the proper procedures. It's very specific procedures you have to follow to set it up in order to even obtain a dismissal or have a chance. And a lot of lawyers just don't read the rules and don't follow those procedures. So if you don't subpoena the officers and they don't show up, you're not going to get a dismissal. You have to go through those procedures to make that happen.
Wow, that's crazy. So I know that we're almost about out of time, but one more question. Have y'all noticed a decline in the number of DWI cases after like Uber and Lyft have become a thing? No?
No,
Wow.
it didn't even go down during COVID.
Oh,
It did
really?
not go down. It did not go down. We were, that was the running joke. Like, where are these people drinking if everything is shut down? But yeah, it has not gone down. People will drive. They don't want us, the $40 for Uber is too much. So they take their chances and get home. And the one thing that we see, and I'll tell this to everybody, you get stopped based upon how you drive sober. Because you're driving on rote memory. If you don't make turn signals when you're sober, you're not going to do them when you're drunk. If you don't yield right away when you're sober, you're not going to do it when you're drunk. So if people just followed the rules when they were sober, they wouldn't get stopped 90% of the time.
I've never thought about it like that, but that's a good point. You can change lanes during the day without using your signal all day long. Roll a stop sign on a right turn, they're not going to get messed with, but you do it at night, every time it's going to be a stop. So my family gets tired of me hearing me say, use your blinker when I'm driving with them. You just change lanes without using your blinker. And it gets aggravating, but it's a reason, because that's probably one of the number one reasons people are arrested at night, not using their blinker to change lanes or speeding just a little bit. But Zarwaki's absolutely right. You've heard sometimes people say they drive better when they're drunk. There's a different way to look at that. If a person is paying attention, that could mean I use my signal and I don't speed if I've been drinking. But I know people think that it means that in their mind, they think they're a better driver. But if you had been drinking, you got to follow every traffic law to the T, because they're out there looking for you at night. I was going to say one I forgot what it was, but that's a really good point.
Okay, well, thank you both so much for participating in this. This was super, super interesting and helpful. So yeah, thank you all so much.
Thank you.
Okay, enjoyed it. Thank you, Zarwaki. Always a pleasure. Katie,
Thank
always a pleasure. Invite me back anytime. I appreciate it. Everybody have a good holiday and be safe out there. You don't want to see me and you don't want to see Zarwaki, I promise.
At all.
Okay. Take care.
Take care.
All right. Bye-bye.